As Athena mentioned, my name is Valeria Rodriguez. I'm with Immigrant Legal Center, and I am located out in the East Scottsbluff office. I am what's called the Department of Justice Accredited Representative. So what that means is that the Department of Justice has granted me with the certification to represent immigrants within United States citizenship and immigration services. So when individuals are going through the process to obtain their green cards or their citizenship, I'm able to represent them as their legal representative. Even though I don't have my JD, I'm able to still represent them. And so today I'll be discussing an overview of immigration law that may impact our agricultural workers. But before I do that, I'd love to share a little bit more about Immigrant Legal Center. Immigrant Legal Center is a nonprofit organization that's providing high quality immigration legal services, education and advocacy in Nebraska and Southwest Iowa. As of October of this last October, we merged with the Refugee Empowerment Center. And so we are now one agency that's also providing refugee services as well. And so we're on the works of rebranding our organization now that we have merged with REC. And so that's just a little bit about who we are as an agency. And so, as I mentioned, I'll be discussing some of the key terms regarding immigration, understanding immigration relief, and seeking in ways that our agricultural workers and individuals you're working with that may need our services, how they can seek those services. I will say at any moment, if you have any questions as I'm going through the presentation, feel free to jump in and ask them. I think it'll be easier during that time at the moment. So first and foremost, what are some of the key terms? We always like to talk about the key terms just because there's a lot of different terms that we utilize in talking about our immigrant population. And so for the first is non-immigrant. So who is a non-immigrant? And a non-immigrant, they're individuals that have been admitted to the US for a temporary period of time in a purpose. And so for these, it would be like individuals coming with a tourist visa, individuals who are coming as a student with a student visa, or, we're talking about work visas. And so these would be those individuals who are coming for a specific amount of time for a specific purpose. Now, our immigrants are individuals that have been admitted to the United States without restriction as to the length of stay. So their intent is to stay in the United States permanently, or they're individuals who have become lawful permanent residents within the US. And so terms within immigrant population is green card holders. That's the legal permanent residents. Asylees, individuals who have obtained an asylum status. They came to the United States seeking asylum. They've obtained that status, and so now they're asylees. Our DACA recipients, deferred action for childhood arrivals. These are individuals that came to the United States. Their parents brought them to the United States, and through DACA now have a protection from deportation and work authorization. They're immigrants because their intent was to stay, when their parents brought them when they came to the United States. However, they have no pathway towards obtaining a green card or citizenship. Special immigrant juvenile status, we'll be talking about this status in the presentation. And undocumented. And so undocumented are individuals that do not have any sort of legal immigration status because we have outdated immigration laws that don't allow them to have that pathway. And so oftentimes we hear individuals say the term illegal aliens. And so we like to stay away from that term because no human being is an illegal. Coming to the United States unlawfully is a civil offense, not a criminal one. And so we want to use the term undocumented. And so that is an overview of key terms. Overview of immigration law. So there is more to what I'll be discussing today, but today I'll be talking about family-based immigration and 3 components within humanitarian-based immigration, and that is U visa, T visa, and special immigrant juvenile status. Within immigration, there's also employment-based immigration, lottery, the diversity lottery as well. But our organization, we don't practice those 2 forms of immigration relief. And there's also other forms within humanitarian-based, like asylum. But for the purposes of this presentation, I decided to focus on these components because we tend to see more of our agricultural workers fall under these categories. And so to start off, family-based, what are the family-based options? And so family-based is when you have an immediate relative who's either a United States citizen or a legal permanent resident that can petition for you. And so when we say immediate relative, what does that mean? It doesn't mean grandparents, cousin, aunt or uncle. It means immediate. And so, you know, these are our parents, a spouse, or your children. And so we have immediate relatives. A visa is immediately available if you are the spouse of a United States citizen, if you are the child, if you are children, unmarried and under 21 of a United States citizen, if you are parents of a United States citizen. And so you have the immediate relatives, and then we have preference categories. So outside of the immediate relatives, then there's preference categories. The first preference category are unmarried sons and daughters over the age of 21 of United States citizenship. So in this one, you see the difference from the immediate relative is that these individuals are over the age of 21, as opposed to immediate relatives are under the age of 21. The second preference categories, now these are legal permanent residents. These are spouses and children of legal permanent residents, unmarried sons and daughters over the 21 of legal permanent residents. The third preference are married sons and daughters of US citizens, and this is regardless of age. And the fourth preference are brothers and sisters of United States citizens. And so just to put all of this into context, I'll share with you my own personal story. My family and I, we immigrated to the United States in 2000 when I was 5 years old. My dad, he had already been here in the 80s to work in the fields with his family. And so that's how he was able to obtain his legal permanent residency. And so he entered lawfully. My mom came in with a border crossing visa, and my siblings and I, we entered unlawfully. And so my father became a US citizen, and he was then able to petition for my mom, my siblings, and I to adjust our status. So he was that we fell. Hello? Okay. We fell under the immediate relative status, under the immediate relative category. And so my dad, he petitioned for us. We got our green cards when I was in 5th grade in 2008. And then my junior year of high school, I was able to become a United States citizen. And so another example, and to put this into also perspective in terms of how long some of this takes, I'm going to take the example of an F4 category. So I now have my citizenship, and let's say I have a brother who is in Mexico, and I'd like to petition for him. So as we looked prior here, brothers and sisters of a US citizen, that's for preference category. And so then we look at the date for Mexico. They're currently reviewing applications from April 1st of 2001. And so we are in 2023. And this process, you would think that it would move forward every day. It doesn't. It stalls. It can stay in 2001 for years, but it can also go backwards. And so when individuals say, well, why don't you just get in line? This is the line that individuals would have to get into, and it takes years and years and years. And the other thing is that within this F4 category, within all of these categories, there's only a certain amount of visas that are available. So for F4 category for siblings, they only grant 65,000 visas per year. And so that is why there is a backlog, and that is why this process takes so many years. My supervisor has done the math, and it can take an individual over 130 years before it would be their time to immigrate to the United States. We see the F2A category, which F2As, spouses and children of legal permanent residents. So if I'm a legal permanent resident and I am married to someone, my spouse, then that category is current right now. So that is to say that if I submit an application for my spouse, then it's current. We don't have to wait. It may take about a year, 2 years, just because of immigration processing those applications, but that category is current. So that's just an overview of family-based. Any questions within family-based immigration?
Hi, Valeria. I put it in the chat, but I also had a question. What happens if the immediate relative, who is the one that's petitioning for their family members, dies while they are in the application process?
So they are still able to continue with that process. They would just have to submit an additional application for that, but they are still able to continue with the process. There is a certain amount of time, though, before someone can submit that application. So if, I just recommend for individuals to seek legal counsel so that they don't miss any deadlines, and making sure that they submit the right application after a family member passes away. Any other questions? The next two are humanitarian relief eligibilities. So U visa, T visa. So within a U visa, individuals would have to be a victim of a qualifying criminal activity. What are these qualifying criminal activities? Here is a list, an extensive list of qualifying crimes that if an individual is a victim of, they may be eligible for a U visa. And within our, agricultural workers, that's worker violations that they may be a victim of, if they didn't get paid, fraud and foreign labor contracting, those individuals coming in on a work visa, if they're not getting paid or not, if there's violations within that contract, that is a way for them to obtain a U visa. They have to prove that they've suffered substantial physical or mental abuse, that they possess information concerning the qualifying criminal activity, that they have been, is being, or likely to be helpful to federal, state, or local law enforcement agencies in the detection, investigation, or prosecution. Criminal activity occurred in the United States. If they are admissible to the U.S., or they do qualify for waivers. And certain family members, they may benefit as derivative applicants, and they can obtain a work permit while the application is pending. This process is new, as of about a year and a half ago, give or take, that they're now granting bona fide determinations for pending U visas. And so now an individual can obtain a work permit while their U visa is pending. And a part of this process is that the individual, we would have to obtain what's called a U-cert from the agency that's doing the investigation. So if an individual, if their worker rights were violated, let's say there was a fraud in foreign labor contracting, then we would need to have the agency doing that investigation, whether it's Department of Labor, to complete the UCERT. Once the UCERT is completed, there's 6 months. We've got 6 months to complete the U visa application and to get it to immigration. If the 6 months pass and we don't complete that, then we need to have, for example, Department of Labor to obtain a new UCERT, or whoever that agency is that's doing the investigation on the criminal activity to complete a new UCERT. And then again, we have the 6 months deadline to complete the application, put together the evidence and so forth, and submit to immigration. Now, T visas. T visas are for individuals that are a victim of a severe form of trafficking, that's sexual or labor, physically present in the United States, American Samoa, Northern Marina Islands, or a port of entry on account of such trafficking. It complies with reasonable request for assistance in the investigation or prosecution of acts of trafficking. They would suffer extreme hardship involving unusual and severe harm upon removal from the United States. Again, if they're found inadmissible, there are waivers for those inadmissibilities. And as with the U visa, there's also opportunities for their family members to be derivatives. And the other thing to mention is that an individual can qualify for both a U visa and a T visa. So both applications can be submitted at the same time. So that was one thing that I'd like to disclose on that. And as mentioned again, here are the qualifying crimes of individuals that may that would qualify for under a U visa: abduction, abusive sexual contact, blackmail, domestic violence, extortion. You know, in the workforce, oftentimes we hear we hear from community members that their employers will threaten them to contact immigration, to contact ICE if they don't work for them, if they don't complete the labor and so forth. And so that could be a qualifying crime that they could be eligible for a U visa. But when in doubt, if an individual is a victim of a crime, but you're not certain if it would be a qualifying crime, you know, that's why our agency, we're here, and we can definitely provide a consultation to evaluate if indeed it is a qualifying crime. It may be that we've had cases where law enforcement will investigate the crime, for example, as a simple assault, but then we find that the individual actually utilized a form of a weapon to beat the individual. So the facts show that it was a felonious, that it should have been investigated as a felonious assault. So oftentimes we have provided the argument with law enforcement, and law enforcement has completed and signed the UCERT for us to be able to submit a U visa for a community member that indeed was a victim of a felonious assault, for example. And so, like I said, when in doubt, just seek counsel, and that evaluation can be determined. Any questions within U visa, T visa? No? Okay. The next one is special immigrant juvenile status. And so I decided to talk about this in this presentation because we've recently seen you know, individuals, youth, minors working in meat processing plants and cleaning and so forth. And so if you're working with youth, this may be something that may impact your field. And so the special immigrant juvenile status is a protection for youth that have been abused, abandoned, or neglected children that are here in the United States. They would have to be involved in the state court proceedings by allowing them to apply. This would allow them to apply for permanent resident status in the United States. And so the qualifications and eligibilities for that is that they'd have to be under the age of 21 years old, unmarried. They'd have to be present in the United States and subject of a state court order finding the following before the child reaches the age of majority. And so during the court order, the judge would have to find the following findings, which is that they have been abandoned, abused, abandoned, and or neglected by one or both of their parents, that reunification with one or both of the parents is not viable, can't take place, and that the return to country of last habitual residence is not in the best interest. They cannot return to their country of origin. And so oftentimes we'll hear of youth that have immigrated to the United States unaccompanied. They're here with an aunt, an uncle, or grandparents. And so they may be eligible for the special immigrant juvenile status. That's if they've been abandoned, abused, or neglected by one or both of their parents. And so, as I mentioned, a court order, court proceedings would have to take place. And these are some of those court orders that can take place in order for a judge to find those findings that they've been abandoned or neglected by one or both of their parents. That's a guardianship, conservatorship, custody, dissolution, legal separation, probate, adoption. And so with this, without the court order, the child, they cannot apply for SIJS unless he or she has the predicate state order with the necessary findings. So once this court order has taken place and the findings have been met, they're then able to apply for the special immigrant juvenile status in front of immigration. We do like to disclose that the SIJ, the findings that the judge makes in state court, it does not make any immigration decisions, but just states the factual findings that this youth has been indeed abandoned, neglected by one or both of their parents. And once this process has taken place, the predicate order has been completed, they have submitted their application to United States Citizenship and Immigration Services. It's been approved. They're then eligible to obtain their legal permanent resident status. Now, once they've obtained their legal permanent resident status, they would not be able to petition for any of their parents. We learned earlier regarding family-based immigration that a legal permanent resident can petition for a family member, but because this special status is because they've been abandoned or neglected or abused by one or both of their parents, and that they cannot then apply for their parents who indeed did this to them. Any questions within that?
Valeria, if they can't petition for their parents, could they petition for another sibling?
They can petition for a sibling. Mm-hmm. I can definitely send over the slides. Okay, when you mention parents, does that mean also guardian? Some that come to the States just come with other people that are not parents per se. Can you elaborate on that question?
Yes, so I'm sorry. So I know a couple kids that come in, cross the borders and everything, but when they come here, they're not necessarily with parents. They're with other types of guardians, aunts, uncles, or I think other people too, in which they're released to, but then
Correct.
they could be having issues there too, where people are not necessarily taking care of them or wanting to take care of them any longer.
Yeah, we've seen a lot of cases like that. And we recommend that they contact our office if they are coming here as unaccompanied minors, and they're living here with other guardians. They may not be able to grant that guardianship to that individual if indeed they are having issues with that guardian. So perhaps there's another guardian in their community that can take over that guardianship, so that they can go through the state court findings that they have been abandoned, neglected by one or both of their parents. Now, if they haven't been abandoned or neglected by one or both of their parents, and they're being abused in any other way, there's possibly, we talked about the U visas. If they are a victim of any of those other crimes, then there may be other forms of immigration relief for them. I hope that answered your question. Any other questions? What are some of some other cases that y'all see in the field in working with the immigrant agricultural workers or just immigrant community members? Do individuals feel comfortable in disclosing their immigration status? I have seen a lot of people from Mexico or refugee status. Is that something new? So their individuals from Mexico cannot seek refugee status. They can go to the border and seek asylum. But right now, with everything that's happening up at the border, the seeking the asylum, they're doing it, they have to stay in Mexico while their asylum case is pending. There are some individuals, that came to the United States prior to those changes at the border and have a pending asylum application. The difference between asylum and refugee is that individuals that have refugee status, they were granted that status abroad. So we see a lot of individuals abroad that coming from with their refugees. So individuals from Afghanistan that have been granted refugee status, and then they come to the United States already with that refugee status, and then they're able to get their green cards. The difference between, so their status is completed abroad, right? They've obtained that status abroad. Asylum seekers, asylees, are individuals that are presenting themselves at either border and are requesting asylum. So they have to have, oftentimes at the border, they'll do a credible fear interview that they fear returning to their country of origin. And then they have a 1-year period to submit that asylum application. And they have to demonstrate that they've been persecuted by due to their religion, national origin, member of a particular social group. There's 5 I'm missing 2: religion, race, and I'm missing a 5th one. But they have to demonstrate those within the application. And then, so they have 1 year to submit their application. Then after that, they would be eligible for a work permit while their application is pending. And then after that, then they would present their case in front of one of two things would happen. If they're already in immigration proceedings in immigration court, then their application would go through a judge, and the judge would make that decision in a trial. Or if they're not within immigration court, then it would take place within United States Citizenship and Immigration Services, is where their asylum hearing would take place. And so perhaps that's what you're seeing is Mexican nationals that have a pending asylum, but it wouldn't be refugee.
So they are here legally.
They're here with asylum. Yeah, they've entered seeking asylum, and seeking asylum is a legal form of relief that the United States government has put in place, and that they have a pending asylum, and with that have a work permit and so forth. So, and they can also obtain their driver's license while they have that pending asylum case.
Also, okay, because I have been helping families, and that's the story they have been given, that they're here legally, but they're not allowed to work yet. They're not allowed to drive yet. If they get caught, they will be sent back. And the reason some of them are here, it's a particular situation with the cartels recruiting their younger 12, 13-year-old boys. And, you know, and that is why they went to the embassy or wherever they had to go to get to the United States, but from what I read in the documents they brought in, because they want to seek employment. They can't get any assistance without any social security number. And their court date or whatever it is, they have to go to their interview, was delayed back. It was supposed to be this December, and now they moved it to 2024. And they're desperate because they don't know what to do at the moment. If they have to live with a sponsor, and sponsors after a while do get tired of having to take care of these families, because they could barely take care of their own, but they don't know what to do if they don't have a work permit. But from the papers, it seems like they're here protectively. So I don't understand, how they could attain that, so I could help them get whatever they need, a work permit or whatever.
Yeah, they may have presented themselves at the border and have perhaps said notice to appear is what those documents are, and they have to appear in front of immigration court. I would recommend them to contact our Nebraska Immigrant Legal Assistance Hotline. This is how an individual across the state of Nebraska and Southwest Iowa can obtain our services. Our services are free if individuals are below the poverty guideline. And so they would call. Our colleagues would do an intake. They would ask a series of questions. When did they enter? Do they have any family members that have immigration status, etc.? That way they kind of know what sort of case it'll be. And then we do have a wait list. So they'd have to wait on our wait list. And then after that, then they would get called for a consultation. But individuals, for example, that have entered the United States seeking asylum, our NELA colleagues are well aware of the 1-year deadline, and so they will get a consultation before that 1-year deadline is up. I would definitely send them over and having them contact our office. It sounds like they have that notice of intent to deny, or not the notice of intent to deny, sorry, the NTA, the notice to appear. And it would be good for them to also have legal counsel when they're going to their immigration court hearings as well. But if they have not submitted their asylum application, then there is no way for them to obtain a work permit. But you know, perhaps there's other forms of relief for them that's not just asylum now that they're in the US. But that's why they should contact our office so that we can provide an evaluation and analyze their situation better.
Thank you.
Mhm.
Valeria,
Mhm.
this is Lori with Department of
Lori.
Labor. Hi, how are you? You know, one of the things you asked a question, do undocumented migrant seasonal farm workers not feel comfortable disclosing that they are undocumented? You know, there is a fear in the communities that we work with, and with those individuals, we do have a complaint system through the Nebraska Department of Labor, where individuals who are maybe being mistreated, not being paid for their work that they're doing, you know, just a number of different things. They're able to work with the Department of Labor to submit a complaint for investigation and to seek assistance with whatever it is that they're needing. But quite a few of the individuals we see that are undocumented just prefer to remain anonymous and not follow through with the complaint for fear that there will be retaliation and that the employer would contact immigration and report them. So there is quite a bit of fear, and unless there is, you know, kind of as you've explained, you know, where there would be some law enforcement would be involved, there would be clear evidence of trafficking and things like that, then it's almost like they're kind of out of luck for, I guess, for support and assistance there. And so they just prefer to remain anonymous and not follow through. And we see so many injustices, but without someone stepping forward to say, this is who I am, and this is exactly what people are, these employers are doing. It's kind of difficult for us to also support them without that.
Yeah, and then like, I think as advocates and practitioners, I think we really need to, and I'm including myself there, in making them feel comfortable and moving forward with that complaint, because without them doing that, then the injustices are going to continue with other immigrant community members. We've seen quite an increase of individuals coming to our office and letting us know that, you know, their employers threatening them to contact ICE if they don't do the work, or that they're not being paid. You know, it's been 2 weeks and they haven't paid their 2 weeks worth of work and so forth. And so, you know, as long as they're making them feel comfortable, going back to making them feel comfortable, and is building that trust and letting them know that their employer, if they file that complaint, their employer can't contact ICE on them, because then, you know, if indeed it is one of those qualifying crimes, then the investigation takes place, and so then, you know, with a pending U visa, they're protected from being deported. And so I think also that providing that certainty, and just letting them know about, you know, if they don't move forward in filing the complaints, then unfortunately these injustices are going to continue. But letting them know, you know, if you move forward with this is what can happen. This is the, you know, that, you know, they can seek immigration relief in that way, but they have to move forward with the complaint. It's the same with any other crime. We see individuals you know, fearing calling law enforcement for the crimes that they've been victims of. And I think that, you know, we definitely understand that fear, but I think, you know, building those relationships for us as agencies with law enforcement, and ensuring that law enforcement is trained and it knows how to work with our immigrant community members as well, so that they don't, so that they are able to build that trust, and individuals are able to feel more comfortable in contacting law enforcement, and, you know, also, you know, for example, the Department of Labor, and completing those those complaints. But I think it's going to take time to remove that culture, just because it is instilled in our immigrant community. I remember when we were undocumented, just seeing a police officer, we would tense up and, be in that fear that they may pull us over or anything. And so I definitely understand where that fear comes from. But I think just creating that certainty that, there is forms of relief if they're seek that complaint in that investigation. Otherwise, things won't change. That employer is going to keep doing what they're doing. And we're seeing an increase of that, especially in the restaurant industry. We've seen many community members coming in that they're being abused in the restaurant industry.
Valeria, sorry, I
Mhm.
want to step in to mention that sometimes, and I don't know if this goes along with you guys, but I did refer a family over because the issues that we're having with migrant workers is that sometimes I think they're qualified as contractors. And so then sometimes they bring in families. And so then, like, let's say the job hires, I don't know, Juan, but then Juan brings in other workers, which are families or whatever, and then they're the ones that are paying those family members. And so they're getting abused from their own families. So, I mean, I guess I don't know. In regards to that, how do we go about in that? And that's happening a lot. I feel like in the current chicken broilers that are popping up in around these areas. What would you recommend? Just, I mean, like my families are very open with me. They will tell me, like, I don't have my papers, they will explain everything to me. And I'm grateful for them to let me know that. But then we feel stuck, like, yes, that's your family, but that's not fair that you haven't gotten paid 2 weeks. You have kids too. So does that fall under the same thing too, as if it were the
If
job?
that family member is the employer, I would have them contact our office, so we can better evaluate that. I think that's the first that I've heard something like that. But I
Okay.
would, refer them over.
All right. Thank
And
you.
I think you asked the question of regarding our wait list currently.
Yeah.
We do have a long wait list. I will say that. But we are trying to hire more staff to get through that wait list. At the moment, we have about 600 plus individuals on our wait list. But like I mentioned, it also, based on the urgency in the case, there's some individuals that would be able to seek quicker services. Someone asked regarding, are the asylees given a number of identification that can use at the DMV? I had one person wondering if she had to provide something like that. So when an individual has a pending asylum application, they will receive their receipt notice that states that they have a pending asylum application. But then once they've had that asylum application pending for over 150 days and or 180 days, then they're eligible for that work permit. Once they obtain that work permit, with that work permit is how they're then able to go and with that evidence, with that permit, go and get their driver's license at the DMV. That's what they would demonstrate, is that work authorization permit to obtain the driver's license.
Can you guys hear me?
Yes.
Okay. So I do have a family that says that she's a person that says that she is like studying the DMV book, but she has not even had the first appointment, like the immigration appointment to get her the asylee status. So meanwhile, she can't go to the DMV and try to get her driver's license, correct?
Correct. She would
Okay.
have to have some form of
like identification number,
like that work permit. And if she has a pending asylum and she hasn't applied for a work permit, That's like a separate application. So once an individual submits their application for asylum, they have to wait, like I said, either 150 days or 180 days, depending on their case. And then they're eligible to submit their application for a work permit. So if she hasn't done that, I think she should definitely contact her legal representative that submitted that asylum application, or if she doesn't have counsel, then definitely contact our office so that she can submit that work permit application, because they are separate. You submit the asylum application first, and then after that, you would submit the work permit application.
Okay, now, just another quick question. For example, for say we have a TN worker, brings his wife, can the wife as the accompanied person get her driver's license?
On an I-10?
A TN visa?
TN visa. I guess I'm not familiar with that visa.
I think that's correct.
As long as
Like-
they're demonstrating with the DNV, as long as they're demonstrating that they have a legal immigration status, then they should be able to obtain a driver's license if they have a legal form of immigration status.
Okay. Thank you.
Yeah, an I-10 number doesn't work for DMV. Yeah, I've never heard of a TN visa.
I have a question. If there are couples and they submit the asylum, did both of the husband and wife have to apply separately for the work permit, or just one member of the family?
No, it would be a separate applications.
Be a separate, okay, thank you.
I think we've got about a minute left. The one thing I will say, when in doubt, just contact our NELA, our access, the National Immigrant Legal Assistance Hotline, for your clients or individuals you're working with to seek legal counsel. Like I said, we are free. If it's urgent, we do provide a referral list of immigration legal providers in the state. There's Catholic Charities as well, depending on where you're at in the state. Centro Hispano Comunitario out of Columbus, Multicultural Coalition and GI, and so there are other legal providers in our state that can definitely help, and we provide that referral list if individuals, if there is an immediate need and we can't assist them, we do walk them through that referral list.
Valeria, thank you so much for your presentation this morning. We had lots of questions, which was really excellent. Please continue to post your questions in the chat if you're interested. But I do want to thank you so much for your time. I did put a couple of resources regarding the TN visa in the chat. Danny and I recently wrote a paper about the TN visa and how it's being used in agriculture, which you have a link to it there in the chat. If you'd like a copy of it, you can shoot me an email and I'll send it to you. And just wanted to note that through the TN visa, a person is eligible to bring a family members or dependents through a TD visa, But all of the process, that would be questions for Danny or for other attorneys who may be able to answer those better than me.